You write me, Booker at bookerlawfirm.com. Your question ends up on the show. Bring you to the court of my public opinion. We're not going to look at this as legal advice because I don't represent you and I may not have all of the facts that I need. However, I'm going to do the best job that I can with what I have. Without further ado, let's get it crack-a-lackin'. Order in the...
It's time I made that call. I'm locked up and facing charges. Who gon' fight these cases for me? I called Booker Law Firm. They got the job done. They were right there for me.
For more information, contact the Booker Law Firm at 713-292-2225.
Hi, how are you doing, African diaspora? It's your favorite attorney, Attorney Ali Booker. And today we are going to speak about the lawsuit that the gentleman in Kentucky filed, okay, due to discrimination because at the jail, they made him cut his locks, okay? And so I want to discuss the legal ramifications of this because we do know that there's a Crown Act that was passed. And this is something that affects all of us in the African diaspora. We as blacks and browns have different texture hair and different types of hair. We do all types of things with our hair. We lock our hair. We have braids. A lot of women have hair weaves, etc. And these things are indicative to our culture, okay, and to many of our religion. And so the issue behind it is that it is a First Amendment violation, okay, for you to force a person to cut their hair, okay, due to their race. Generally, it's race, okay, or their religion. And you cannot force them to do this, stating that you have some government interest that you're upholding and forcing them to do this. So let's go a little bit more in depth with what happened with this particular gentleman, okay? In Kentucky, a black man sued the facility. His name is Carlos Thurman. He's 50 years old. He's a Rastafarian. And he was forced by the officials at the North Point Training Center prison to cut off his locks. Sorry. And we know that that locks are a hairstyle commonly worn, okay, by Rastafarians as a symbol of devotion to their creator. And they're commonly worn by African Americans, okay? It is a huge, and especially now, guys, with natural hair, it is a huge, it's becoming a big deal, okay? So this gentleman made him cut it. This gentleman was made to cut his locks off, and so he is now sued. The American Civil Liberties Union, ACLU, have brought this claim on his behalf. And what they're doing is attempting to move forward. In my opinion, they're attempting to advance the Crown Act because the legislature, United States legislature, has not been able to do so. This bill was basically brought about in 2019, and the bill has passed in the House of Representatives. It has not been before the Senate to be codified, and that is the issue. It's being held at the Senate. And we all know that there is an issue with respect to the Senate and who holds the majority. So right now, the Senate is able to block a lot of bills and stop them from becoming laws by filibustering, etc., or by moving things off of their templates for the meetings. Due to the fact that there have been issues with Corona, a lot of things have been kicked back and they have not been addressed. However, the House of Representatives did make sure that they pushed the Crown Act through, and now we're just waiting on the Senate. So now that we're waiting on the Senate, this gentleman has come about. He was arrested. He was imprisoned. He was forced to cut his locks because he was being transferred to another facility. And in this particular jurisdiction within Kentucky, they state that, the policy states that if inmates have hair that makes it hard or difficult for them to search through it when they are being transferred to another facility, placed in solitary confinement, or appearing in court, this hairstyle must be done away with. And so in this particular case, the only way that you can pretty much do away with that hairstyle is to cut it. Okay, and subsequently that was done. With respect to passing a bill into law, guys, there are many ways that you can get laws passed. Although they can only be passed in and through the legislature, there are ways to get them recognized. So the ACLU is very smart. What they are using is the First Amendment, guys. The First Amendment, freedom of speech amendment, to challenge this particular law. And the argument behind it is you cannot mess with the rights of the United States citizens that are guaranteed to them underneath the United States Constitution. Okay? If you are going to abridge someone's rights underneath the Constitution, you have to make sure that there's no other way, okay, that you can further the government interest, okay, other than to violate or abridge these constitutional rights, and it will only be in certain circumstances. So the issue before the court right now, federal court, is whether or not this policy is met with strict scrutiny, meaning met with very close eyes, okay, and whether or not that court is going to determine that there is no other way that this hair can be searched other than to cut it. And if so, we have to make sure that the government interest is really a big government interest that we are trying to meet. So this is the argument behind it. The argument behind it is that there is a very severe government interest, okay, within making sure that contraband is not disseminated or distributed in and through jails, disseminated or distributed in and through court systems or otherwise. It's for many reasons. Number one is for the protection, okay, of other inmates, of the staff, and of the court personnel when a person is going to court. When a person is in solitary confinement, they want to make sure that they're not able to get their hands on any contraband that they can use to possibly hurt themselves. So that is the government interest that they are seeking to protect with this policy that says you can't have this hair that is hard to search. Now, because this lawsuit has been filed, the federal district court now has to look at this policy and look at the government interest of ensuring that contraband is not taken throughout the jails and ensuring safety. And they're going to have to look at it with strict scrutiny and determine whether or not there's another way that this prison system can get to that same result. Meaning, is there another way that they can ensure that hair that is difficult to search can be searched for people going in solitary confinement, people being transferred through prisons, and people who have to go to court? If the court determines that they have other ways that they can search this difficult hair, they're not going to let them cut it. And what that's going to do is that's going to solidify that Crown Act, although the Crown Act has not been passed. It's going to solidify the Crown Act in and through what we call stare decisis, or on the judicial branch. Because the judicial branch interprets the laws. So there are two ways that they're fighting to assist us with our hair. One is through the Crown Act, and because it's going slow, now that they have cut this gentleman's hair, they're using that avenue to push through. Because even if the Crown Act has not been codified, this finding is going to be very important because the rest of the courts will have to follow it. And at that point, the court is going to say whether or not they believe that there is a true government interest in cutting black folks' hair. And then when you're dealing with cutting people's hair in prison systems, although this is a state prison, it's going to walk on over into the private sector, and it's going to give us some understanding and guidance with respect to jobs as well. Okay? So this is a huge landmark case that we all need to be paying attention to. It affects all of us. Okay? If you guys have any questions, comments, or concerns, put them below. Make sure you send any questions to me, booker@bookerlawfirm.com, any topics that you'd like for me to cover. Make sure you add me on Instagram, she_ya_lawyer. Also, follow me on TikTok, Legal Q. That's the letter Q. That's the letter TEE. And I also have a YouTube channel where I expand on different types of law as well. Until next time, guys, I'm going to go ahead and we're going to put court in recess. Okay, let's bang that gavel, African diaspora. Court is in recess until next time, guys. Thank you, and y'all have a fantastic night and or evening. Goodbye.